But one request, it should be pertaining to this bench.
Yes, Lord.
Okay.
I beg to mention for listing quashing petition day after tomorrow, Milo.
Let us have it on 24th. Huh?
Hence in the
You do it tomorrow? Well,
12 page, 1 2.
1, 2.
Ask for the day, Lordship.
On the prayer of Mr. R. Ali, Learned Counsel for the petitioner, matter stands adjourned and be listed
Next week, Lordship.
next week.
may I please your lordship? 510 of the 24. 510 of the 24. LCR has been came. The case for tomorrow.
What is that? It's a bail,
For-
criminal petition or
For what?
quashing?
Admission?
For motion.
How motion? LCR came.
What is the stage of this case? You just verify, then make a mention tomorrow. Yes, next.
LCR has been came.
LCR call, what is the stage? Admission, order, whether notice has already been issued?
Order.
Notice has already been issued. Are you aware? You are not aware of anything. Yes, next case.
Okay. Your lordship, I listing bail application.
Bail application at what stage? Motion? Bail hearing? Already CD is called. Don't come here without knowing anything. Yes, next case. Next case.
May I please your lordship? Lordship, I beg to mention item number 10, my lord. Counsel A. Ahmed has some personal difficulty, my lord. I adjourn the matter for today on.
Same order I got to listen. Yes.
Apply.
Wait, please, your lordship. Matter was supposed to be listed after 1 week from last listing. Not been listed yet. So it may be listed this
What
week.
is the matter about?
Criminal revision petition, 1/7 of 24.
When last listed?
24/4. 24/4/20.
Any date was fixed?
No date was fixed. It was
What is the urgency?
urgency is he is having to pay the maintenance due to an erroneous order.
24th.
Much obliged.
I beg to mention item number 35, Lordship.
35.
Taken up on 30, Lordship.
Okay, yes, CD is there.
Series. As per it.
Any interim? When you want to do it, CD is here.
Senior is indisposed, Lordship. Interim is there also.
When you want.
30, Lordship.
30, you cannot keep the CDs till 30. See the CD, not possible.
Next week,
Or
Lordship.
will you vacate the interim order, return back the CD?
Next week, Lordship.
You say.
24 now. 24 is
On 24th, 24th.
obliged, Lordship.
Wrongly listed, my lord. It should have come as bail hearing.
Ah,
Scan
that
copy
is
all
what.
let's call. Alias scan copy call.
Copy is not received, lord. It's not tagged with the record, lord.
Scan copy is not received. Okay, scan copies called for by this court under this order dated 6/5/2024 is not received. Registry. Reminder. No scan copy is called for. Notice,
So that process is completed, lord.
steps is completed.
Completed, lord.
No, this is in office. Where is the office note as regards service? Notice was issued by the registry on 10/5. On 10/5/2024 through the officer in charge Bokaghat Police Station, Golaghat. However, no further report is there in the office note. Full stop. Sir, can you do it? Sir, it was this notice was directed to be served through officer in charge. You have the instruction.
Copy of this.
No, this is.
I'll have to take instruction.
The process submits that he may be permitted to take instruction from the concerned police station as regards service. There is allowed. List this matter on. What is this application?
Can the scan copy?
Yes, that will call. In the meantime, আগৰখিনি নালাগে can scan copy call for not receiving নালাগে. This is an application under section 439 of the Code of Criminal Procedure for granting regular bail to the petitioner who is in custody in connection with special Pocso case number 84 of 2023 pending in the in court of learned special judge Pocso, Golaghat, arising out of Bokaghat PS case number 124/2023. Full stop. Registry to call for the scan copies of the records of the Pocso case number, special Pocso case number 84/2023, along with the case diary of Bokaghat PS case number 124/2023. List this matter on 6th of June.
Much obliged. Much obliged.
May I please, Lordships? Yes, sir. 439 application, my lord. In this case, my lord, kindly see the FIR at page, my lord, page 10, my lord. Page 10.
Is
In fact, my lord, may
item
I
number?
may I read, my lord?
Is item number 2.
Item 2, my lord. See, the 439 application, my lord.
When arrested?
My lord, arrested on, my lord, 5/5/2024, my lord. In fact, my lord, in this case, my lord, I have.
Sir.
Age is not mentioned, madam.
Age is at page 27.
Yes, my lord. I have an exact document, my lord, and already applied.
Age
my lord.
is at page 27. They intended to marry, but actually we want to see the 164 statement.
Yes, already recorded, my lord.
Okay, that much only. This certificate is
Already.
there from which place?
Bribery.
Available.
Yes, sir, my lord, a 164 statement, there is, my lord, that's why, my lord, kindly, I am praying for short date, my lord.
Short date.
Yes, my lord.
Short date.
Yes, sir.
Apparently,
Nothing is
he
there,
has
my
made
lord.
out a prima facie case. They have intended to marriage. Her signatures are on at page 26,
On 24, madam.
24. Well, on that will otherwise will consider. Have a telephonic instruction or whether you need a custody first. And second is all for case that you wait along with the 160. We are in fact inclined to grant, but we do not know her 160 because her age is just she has crossed 80.
That's
Obliged, my lord. Much obliged.
This is an application under 439 CRPC seeking bail in connection with Abhoypuri PS case number 116/2024 under section 360P IPC. The learned counsel for the petitioner relying on the annexer, relying on the page 27 of relying on the this is admit card.
Admit card 27.
Relying on the admit card of Board of Secondary Education Assam contents that the victim is a major as well as they in fact has the petitioner and the accused in fact has started the process of marriage and they are in a relation. Call for the case diary along with the statement of the victim girl stated to have been recorded under 164. Where is the girl now?
Stay at home, my lord, Jalukbari.
Okay.
Much obliged, lordships. Obliged.
May I please, Your Lordship?
Yes.
439 application, Your Lordship. He was arrested on 4/5/2020. Without issuing notice, he was arrested from his house, wherein he had nothing to do in this matter, Your Lordship. The 13 is the page FIR, where Lordship, the dispute is with wife of the petitioner, Your
To the satisfaction of absolutely civil case. To the satisfaction of
Superintendent Hailakandi.
Hailakandi.
CJM Hailakandi.
CJM Hailakandi. আপনি লিখিব considering the nature of allegation. Peruse the FIR. The FIR reflects that allegation pertains to a contract between the petitioner and the accused person as regards starting a liquor business, isn't it?
Yes, sir.
Starting a liquor business. And fundamental allegation is that after taking money, the accused, instead of inducting the present informant as partner, is trying to induct some other partner, and in the meantime, the informant has suffered loss. Full stop. Considering the nature of allegation as well as the period of detention, this court is of the view that no further custodial interrogation of the petitioner is necessary. Accordingly, to the satisfaction of
Hailakandi.
CJM Hailakandi. Dispose.
Much obliged.
Please, Your Lordship. 439 application, Lordship.
When both of Pocso,
No, Gwalpara Mala
Lordship,
Krishna.
one prayer, Lordship, and out of same FIR, Lordship, one item number 49, court number 18, 2 days fixed, and CD is here, Lordship. Day after tomorrow, can it be? Item number 49, court number 18. CD is here, Lordship. Day
okay,
after,
we're adjourning it till day
day
after tomorrow.
Lordship.
At least this matter day after tomorrow. Is a person note it if that is
In
there.
the hearing list, Lordship. Obliged, Lordship. Obliged.
22.
My please, Your Lordship.
Yes.
Your Lordship, the petitioner is behind the bar since last 16 days, Your Lordship, and the vehicle which has been stolen has already been recovered, Your Lordship.
Where is the FIR?
The fare is page 17, Your Lordship.
Please.
Page 17 is the vernacular, Your Lordship.
When both of
One thing is, no, one thing is that regarding stealing of one bike, I have seen one CD in Gwalpara Malat, 112.
that's why I'm calling for the case diary. When?
Bohisto,
Your Lordship.
24, 24,
24? No, not 20. All cannot be 20.
22, 20,
20?
20.
No, not 20.
Oh, sorry.
Go beyond 24.
Sorry, man.
Huh?
27th, Your Lordship.
27.
27.
I love you, Lordship. Behind the bar, last 29. FIR
तो की बात दिले
Buffalo heads, isn't it? Even if you go through the FIR, there is no allegation that they have stolen it. Just read it. There is not a single whisper that they have even stolen it. To the satisfaction of
CGM South Salman.
CJM South Sarma, considering the nature of allegation, it is alleged. Peruse the case, peruse the material available on record. It is alleged in the FIR that the petitioners were found with how many?
20.
Huh?
20 number of buffalo.
20 number of buffalo heads. Suspecting that to be stolen, the petitioner has been arrested. On the other hand, the learned counsel for the petitioner produced certain document as regards ownership of such buffalo heads. Full stop. pleaded as it may, considering the nature of allegation as well as period of detention. This court is of the view that no further custodial interrogation shall be necessary inasmuch as the buffalo heads had already been recovered and the petitioner has been in custody since
21/4.
21/4/2024. Accordingly, the present application stands allowed.
Physical
Is
Social Manka, sir.
satisfaction of
Physical Social Manka, sir.
Anka, sir.
Please, Lordship.
SCL Act. Yes, when?
Yeah, Lordship. The petitioner is in custody for 1 year, 5 months, 5 days, Lordship.
No charge sheet.
Lordship?
Huh?
Sorted.
Charge sheeted.
Lordship.
We'll call for the scan copies.
Sorted maybe given, Lordship.
Short date is we can fix it tomorrow also,
No, sir.
isn't it?
I don't
But
mean
the
that.
scan copies will have to come.
Yes, Lordship.
Reasonable time. Huh?
First week of June.
The present application is filed under section 439 of the Code of Criminal Procedure 1973, seeking regular bail in connection with NDPS case number 74 of 2023, pending for trial before
Additional district and session judge.
before the additional district and session judge number 3, Kamrup Metro, Guwahati. Registry to call for the record of NDPS case number 74/2023 along with along with case diary of Hattigaon PS case number 573/2022. List this matter on 5th of June.
Lordship, except 5th of June, Lordship, maybe 27, Lordship. That day on
27?
some,
Once 6th or 7th or
before 5th, Lordship.
Huh?
Before 5th, Lordship.
before 5th, 4th, 3rd of June.
Lordship.
56 to.
Yes, what is this?
Please, your Lordship. This is the petitioner is in custody since 19/12/2020.
Where is NCB? NCB's name is shown. Wait for some time. Huh? Oh, sorry. Yes, NCB's name is not reflected. Okay, though this matter is represented by Mr. S.C. Kyle Larned, standing counsel for the NCB, as reflected in his order dated 17/5/2024. However, in the cause list, neither name of S.C. Kyle nor any name of standing counsel NCB has been reflected, isn't it? Huh? Only SGI, DSGI, okay. Accordingly, registry to list this matter on 24th by reflecting name of Mr. S.C. Kyle, Larned, standing counsel for NCB.
Hello.
Please, your Lordship.
Yes.
That on apprehension, that is some news has been.
No, I understand your apprehension, but what is the allegation? Why you apprehend? Nothing is there.
The allegation is there, my lord, that I have collected some money for giving a government jobs, my lord. Page 3 at paragraph 1, my lord.
The present application is filed with an apprehension that a police station first information report might have been first information report might have been registered by the police, and the petitioner may be arrested as there are as some unknown persons has made certain statement before press that the petitioner has collected money to provide governments of. Which state police station will do?
Police station Miller Gudahari.
Huh?
Dolgaon Miller.
Full stop. The petitioner apprehends that the Dolgaon police station might have already registered such an FIR. Full stop. In view of the aforesaid, Mr. Parasar, learned additional public procedural submits that he will obtain instruction from the Dolgaon police station officer instance whether any case is registered against the petitioner. Is this matter on 24th?
In the meantime, no
No,
question.
no, in the meantime, we know nothing.
Kindly, my lord.
Even if there might be some serious that you have collected money, why should we on apprehension? We are fixing it for motion on 24th.
Deeply obliged, my lord.
It is your lordship.
Yes.
Application of the petitioner for Jimmo of the cash is that has been rejected by the London magistrate. Lordship. will
Yes,
find-
was seized in connection with what? We'll call for a report.
My lord, in fact, report was
Report was called for.
called for, but it's not received, my lord, because it's listen motion, my lord. Because of that, my lord, office might not be seen.
Okay, we'll fix it any day, no problem on it.
My lord.
Report is there.
No, I don't know, my lord. In motion column, my lord, because of that.
Okay,
my lord,
because already
on-
now
I think
under what
it's,
circumstances it is alleged to be fake or what? I have not gone.
The allegation is that, my lord, in New Wanga railway station, questioned him and then from his possession, rupees 20 lakhs was recovered. And his explanation before the magistrate also is that, my lord, I am a businessman from UP. For a business in Sukia, I had carried 20 lakhs rupees, but they did not, the
Now,
business.
what
did
is the
not-
offense registered?
And my lord, we have, he has also, my lord, given the document to show, my lord, where he has got that money.
No, now what is the offense
My lord,
under
offense-
which this is seized? On
Offense is that, my lord,
you have carrying money.
it is to be stolen property. There is no FIR against me, my lord. The FIR your lordship will find.
Where is the money kept? Okay, we are giving you a time.
Money has been
One,
kept with the treasury.
okay, treasury. Okay,
Your lordship knows, my lord, for 51 application.
that may be a concern for the income tax officials. Police will
Yes.
immediately report income
he-
tax.
Yes,
They will do the needful.
and we have also, he has also, my lord, annexed all these tax returns also, my lord. And my lord, he has got this amount by an agreement to sell his property. That say, my lord, agreement has also been, my lord, produced before the magistrate, before your lordship. He has got all the explanation.
Yes, when?
on 24th, my lord.
24th? So then only 22nd might be a difficult
My lord, let it
second
be
half,
24.
so
Let it be 24.
24th. Okay, Mr. Parasar, learned counsel, additional public procedure submits that he may be granted time till 24th to obtain to furnish the instruction and report as in terms of this court's order dated 10/5/2024. List this matter on 24th in the admission column. Don't issue to. Ten, okay. Third, no, none appears for the petitioner and court. List after a week.
May please lordship.
Yes.
Last occasion matter was heard and further proceeding was stay, but notice was not issued. Therefore, today matter was list for motion, my lord.
Notice was not issued. Notice to be issued to whom?
To the, my lord, respondent number 3 and respondent number 2 is the
No,
deputy commissioner.
notice was not issued because court was of the view that it's without issuing notice, let us see the record. If we dismiss your petition, why should we issue notice?
Can copy also
Yes.
not come.
Return copy has come. You go through it. Mr.
Yeah.
Parasar, learned counsel, additional public prosecutor submits that he may be granted some time to go through the case record, scan copies of the case record, including the case diary. First of prayer is allowed. List this matter.
Along with, my lord, another case is pending, my lord, along with criminal petition.
List this matter on. Give a date. List this matter on
4th of June.
4th of June. Along with
Criminal petition number 563, public 23.
563 of 23.
563.
The interim order pass earlier shall continue till then.
Please, the Lordship.
Yes.
Lordship, petition under section 482 CRPC.
Mm.
For quashing of Lordship, one complaint case along with the order of taking cognizance, Lordship. The cognizance was taken under section 420 Lordship IPC. And the Lordship will find the complainant Lordship type copy page 17.
Yes.
Page 17, 17. The allegation is that Lordship, there are some business relation and we are about to supply some Lordship.
What is page 20 is the vernacular?
Vernacular, Lordship. Page 20.
Delivery timber, no? 30 lakhs was paid.
Heard. Heard, Mr. N. Hassan, learned counsel for the petitioner, also heard Mr. learned counsel for the public prosecutor. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashing the proceeding of complaint case being CR case number 199/2023 pending before the Court of Learned Sub-Divisional Judicial Magistrate within bracket Sodor, Nalbari, and the further challenge is order dated 26th and 2023, whereby the learned magistrate has taken cognizance of offense under section 420 of the IPC. The basic ground of challenge is that no case under section 420 is made out in as much as the allegation made in the application are civil in nature. First, peruse the complaint petition. Also, the statement of the complainant and other witnesses recorded under section 200 CRPC. First of perusal of the aforesaid material, this court is of the prima facie view that the dispute the dispute on the basis of which the complaint was filed arises out of a contractual transaction between the parties, and the fundamental allegation is that the opposite parties / petitioners have failed to comply fail to perform their part of a contract by the part of a contract, and when they fail to perform their part, and when the complainant demanded return of the advance paid, the informant has failed to return such money. Full stop. In view of the therefore, this matter needs further consideration. Accordingly, let a notice be issued. So and so, Mr. Parasar accepts notice on behalf of respondent number 1 is to respondent number 2 by registered post as well as usual process. Considering the nature of allegation, it is provided that further proceeding of CR case number so and so shall remain suspended till the return of the notice. Notice returnable on after 6 weeks. Give a date.
28th of
Take your best. Wait.
May lordship. Quashing of FIR, my lord. Authority, teacher and student lordship. Only they have settled the dispute lordship. This just go there appeal lordship.
Who was the juvenile? You were the juvenile, the other was.
This was my son lordship. I'm the
The
petitioner,
son was
yes, my son,
juvenile.
lordship.
Where is the other side? It is joint.
Appeal lordship, is notice by go lordship.
Okay. The present application, you are the father of the
Yes,
children.
son, yes.
Present application is filed under section 482 of the Code of Criminal Procedure for quashing the FIR, registered as Sipazar PS case number 303/2023 under section 457/380 of the Indian Penal Code, inasmuch as it is the case of the petitioner that the matter has amicably been settled, and such settlement shall have no adverse impact upon the society at large. Issue notice returnable on so and so.
Dosti notice. Dosti side.
The petitioner is also. Generally in criminal, there is no provision of dusty. Criminal is something different, but we are permitting it's not dusty. Inform him, you yourself be a dusty. Let him appear. People. Notice returnable on 28th of June 2024. Considering the nature of allegation in the FIR and also the fact that the accused is a juvenile and the present application is filed by his father.
His father is also accused, lord.
Okay. Considering the nature of allegation, it is provided that till the returnable that further proceeding of further investigation in connection with so and so shall remain suspended. No search sheet file.
No. Obliged.
May I please your lordship?
Yes.
Lordship, it's a 482 application where the name of the petitioner has been wrong.
Who are you? How you are related to the FIR?
Lordship, if this honorable court sees the FIR, which is in page 18.
Page 18.
Yes, your lordship, and
Yes.
and the main FIR is in page 25, your lordship, which was filed by the informant.
Grandfather,
Your lordship.
grandfather of the victim.
Victim against one Alif, your lordship. One Alif. What permits I may read the FIR.
Just a minute. Alif.
Yes, your lordship.
Okay, now.
Now, here in the FIR, it was stated there that a guy namely Alif, who was a resident of Madina House, of house number 89 of room number G2 of Puran Basti Khanapara, from the last 1 month extorting money from my grandchild. But when the investigating officer went to that room to find out, they found the petitioner in that room. And accordingly, his name has been.
Now, what is the, let there be investigation.
Yes, your lordship,
There
already.
should be only notice.
Let there be investigation and find out that you are not that person.
Yes, your lordship.
The victim children, if
13 years
if he says that you are not the person, Matterance dear, why should you quash it? It is in your interest, investigation should proceed. That's why I was surprised why this is the petition.
Your lordship,
Because the grandfather says his name is Alif, is not aware of the name. You might have said that my name is Alif. Now you'll have to be identified by the victim. That's all.
yes, your lordship, already. No action.
Be happy. Be happy. You want to,
I mean,
okay. Sir, what to do?
your lordship,
Only notice in this case, otherwise, well,
Why should we increase a case in our docket?
lordship, one more thing is that when the
Anybody and everybody will come at any, tell us what is your case.
your lordship, when the petitioner approached the learned judge for take the seize item, quite order dated in a report submitted by the
Sage item, what is the sage item?
mobile phone and the
Okay, then what
iPad.
happened?
And there also, the investigating officer stated that no material mentioned in the FIR has been found from his mobile phone.
Okay, he will give a final report. Why should we stall a proceeding here?
Your
If
lordship,
that is there, what is your apprehension and why are you coming to the court?
it's a case because of which his name has been for this case only. He's just a 6 years old boy, and for this reason, he has, after completing his graduation, he could not apply for any government job.
Why? What is the problem?
Because your lordship, because he's from a different state. He's from basically Tripura, and to apply for certain government job, he need
So you file an application saying that complete the investigation, file a writ petition. We are giving a direction. Why should we quash this?
He's the petitioner, your lord.
We do not know.
maybe there is no case.
Maybe you are the person who says that my name is Alif. That will be of a matter of investigation. If the victim says, no, this is not the Alif, he was somebody else. Matter ends there. What is the ground of quashing?
Your lordship, basically, my name was not there.
Your name was not there, but police apprehended, arrested you.
Yes, your lordship.
You were released on bail. So
Yes, your lordship.
investigation is proceeding. Mr. Parasar, have the scan
Status.
copies of the case diary and status report. Present application is filed under section 482 CRPC for quashing FIR dated 18/9/2022, registered as Dispur PS case number 2141/2022. The case of the petitioner is that the petitioner is not named in the FIR, rather one Alif was named in the FIR to be the accused. However, as the petitioner used to reside at the complex where the address of the accused was given, the petitioner has been implicated and accused and he was arrested. The learned counsel further submits that for the last 1 year, investigation has not been completed. And the petitioner has unnecessarily been implicated, whereas he is no way connected in nowhere connected with the case, full stop. This court is of the view that before issuing notice, let the IU concerned IU of the dispute PS case number 2141/2022 file a status report and produce the case diary so as to ascertain whether the contention of the petitioner is correct. Full stop. Is this matter on?
But
4th of June.
Quickly applies your lordship.
The charge sheet and the cognizance order have been challenged. But you would find the charge sheet at page 21 is the English version and 25 is the vernacular. So I may read the vernacular.
25.
But the incident is that I did not pass a bill even after receiving the Rolex, and I also give bad gestures.
What is the charge sheet under what are the offenses?
Offenses is under 409, 509, 506 to 94. Lordship, may I read the second portion? তদন্তকালীনত মৰ্মে ঘটনা প্ৰদৰ্শন কৰি গুচৰীয়াই তথা সাক্ষী বাদী সোধপোছ কৰি তেওঁলোকৰ জবানবন্দী মৌখিক লিপিবদ্ধ কৰা হয়। সোধপোছ কালীনত যদিও গুচৰীয়াই 2 লাখ টকা বিল পাছৰ নামত দিয়া বুলি কয়, কিন্তু গুচৰীয়াৰ স্বামীৰ জবানবন্দীৰ প্ৰকাশ পোৱা যায় যে পদকীয়াই নিজৰ ঘৰুৱা কাৰণত গুচৰীয়াৰ স্বামী পৰা 2 লাখ টকা নগদ ধাৰত লৈছিল। পৰৱৰ্তী সময়ত গুচৰীয়াই জনায় যে পদকীয়াই লৰেন্স টেৰনে ইমৰান হুছেইন শ্বেখৰ নামত মানুহ এজনৰ নামত 3 লাখ টকা দাবী কৰে আৰু গুচৰীয়াৰ হাতত তাৰ অডিঅ' ৰেকৰ্ডিং আছে। গুচৰীয়াৰ পৰা অডিঅ' ৰেকৰ্ডিং
Why don't you wait till the proceeding under 207? 207 or what is the provision? 206 that is the discharge.
Process.
Huh?
Lordship,
During the framing of charges?
yes, framing of charges, all things.
Lordship, my case is that everything on the charge sheet is taken to be true. Even no case under any offense is made out. Everything is found to be false. Lordship.
That is under that there is a procedure.
This thing
That we understand. Therefore, the legislature in its wisdom has given that whenever an FIR is filed or charge sheet is given, that is not absolute. The court will take a second call whether cases are made out. If not made out, you will be discharged. If this is the material. Why before reaching that stage you are here? Why should we exercise our 482 powers for all these cases? Then we'll convert ourselves into a trial court.
Lordship, also cognizance have been taken at page 28 under the same sections. I am challenging a cognizance order.
Okay, hard. Why this is under 420? What is the 420?
No 420, no offense under any of the sections.
What is 509?
509 to criminal.
Criminal intimidation or what? Huh?
Criminal intimidation. 50, whoever intending to insult the modesty of any woman, utters any word, makes any sound or gestures, or exhibits any object intending that such words shall be heard.
According to the charge sheet, no 509 is made out.
No.
Okay, then?
No 420 is made out.
420 not made out. We see it. What is 506? Intimidation or what was that? Criminal intimidation.
Yes, punishment for criminal intimidation.
Okay.
No criminal intimidation.
Heard, Mr. GP Bora, learned counsel for the petition. Counsel for the petitioner. Also heard Mr. Bora, sir, learned counsel, additional public prosecutor. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for setting aside and quashing. For quashing, not setting aside, quashing the criminal proceeding in PRC case number 506/2024, as well as pending before the learned judicial magistrate first class Sankardev Nagar, Hosai, Assam, and the order dated 4/5/2024, whereby the learned magistrate had taken cognizance under section 420, 509, 506, 294 IPC. Full stop. The informant lodged an FIR inter alia alleging that the accused petitioner had demanded bribe of rupees 40 lakhs.
2 lakhs, Lordship.
Huh?
40 lakhs was the total scheme.
2 lakhs for favorable sanction of a scheme of rupees 40 lakhs. The accused petitioner, who was a junior engineer in the relevant point of time under Binnakandi development block, demanded a bribe of rupees 2 lakhs for a favorable sanction of a scheme for around 40 lakhs. And accordingly, the informant paid a installment. Something was there. Where is that?
Case number 19 is the FIR. Paid 2 lakhs, Lordship.
And accordingly, 2 lakhs were paid. However, the accused gave her inappropriate behaved with her with inappropriate gestures. Full stop. Accordingly, Doboka PS case number 14/2024 under section 420/409/509/503 IPC was registered. After completion of the investigation, the investigating officer filed search sheet being search sheet number 33/2024. In the search sheet, it is reflected that no case of demand and payment of money is no evidence as regards demand of money and payment thereof was found during the investigation. It is also reflected that there is no the investigating officer also could not find any material as regards giving showing bad gestures. Why they don't want to use the words sexual gesture or whatsoever, bad gestures? What is the bad gestures? In the FIR also?
To what extent?
Nothing is there, bad gestures. It's difficult to express what it's anyway, bad gestures. If they have written it, we'll say it bad gestures. Full stop. However, the search sheet was filed. Full stop. The largest magistrate, while taking cognizance, also have not discussed anything that are available on the case diary, inasmuch as it is settled law that issuance of process and taking cognizance is not merely a formal proceeding, and application of mind is necessary. Considering the above, in the accordingly, this court is of the view that this matter needs further consideration. Accordingly, issue notice. Parasa respondent number 1, 2, both ways within 5 days. considering the matter in entirety, provided that till the returnable date, further proceeding of so and so pending before so and so shall remain suspended. Returnable on 5th of June. Scan copies of the issue notice or bishop. Scan copies of the case record hetu dibo and the case diary of police station case number.
May I please your lordship? This matter is for application under section 482 for quashing of FIR and charge sheet, lordship. Pending in special
List
judge-
this matter before any other bench without me.
Fifty-seven, one report was called for but not received,
Okay.
whether in the case of
None appears for a petitioner on call. Mr. Parasar, learned additional public prosecutor, submits that he has not received the he not received the instruction and prays for some more time to obtain the same.
27,
The prayer is allowed. List this matter on
27.
27.
The matter will be passed over for time being.
It is there.
Lordship scan copy.
10 copies. Have you gone through it?
Yes, Lordship.
And appears for the is this matter after a week.
Twenty-six Lordship scan copy was called for but not received.
10 copies received.
Not received.
My lord, can we see 3 times?
Yes, tell us.
My lord, PP has also, my lord,
Now what to do?
instruction from the OC, my lord, regarding service of the notice. Respond number 2.
Pocso.
Pocso, my lord. Almost 1 year. First, my lord, he is in judicial custody, my lord.
Mr. Additional. Yeah, Mr.
B. Sharma.
B. Sharma. Mr. B. Sharma, learned additional public prosecutor, submits that he may be granted further, 3 days further time to obtain instructions as regards service, as regards status of service upon respondent number, status of service of notice upon respondent number 2, from the officer in charge, Doboka Police Station, in terms of this court's order dated 9/4/2024. Prayer is allowed. List this matter on. Is this matter on? Further a week's time, till a week's time. Okay, list this matter on.
Monday.
Next Monday.
Hello.
Next Monday. 27. This court under its order dated 18/3/2024 call for the scanned copies of the case diary in connection with
Doboka case 141 oblique
Doboka Police Station case number
141/23.
Special Pocso case, my lord.
a call for the scanned copies of
ACL Pocso case 179.
scanned copies of the record of special Pocso case number
179.
179. This is the difficulty, even you have
Page
not given in the cost title. Huh?
Page within the bracket
Huh.
of 2023.
Of 2023, and the case diary of Doboka PS case number 141 of 2023 from the learned special judge Pocso, from the court of learned special judge Pocso, within bracket Pocso, comma,
Pocso, comma, 179 within bracket H.
Special Pocso judge
Hojai. However, scanned copies has not yet been received. Registry to issue a reminder forthwith. Place this matter for next. Forthwith, please.
27.
Lord, I am sorry, my lord, item number 25, my lord. I was on legs in court number 8, my lord. Just your lordship is
We'll see. Wait for something.
lordship.
Yes, what is the next case?
27.
Huh?
Lord, FIR lordship may kindly see page 10.
27. Why have you been back to 27? We are in bail. We are taking bail hearing. Why have you called 27?
That's it, because 26 has already been. 26.
We are not on 34, no?
No.
Okay. So I thought that we have started from 34. Yes.
My lord, may kindly see FIR page 10.
Charge-sheeted case.
Charge-sheeted case, trial has started, my lord. Here are three main things. The girl says nothing happened with me. That lordship may kindly see page 19.
What is your name?
My name is Nekibur Rahman. And the FIR was lost. FIR was lost on after 8 days. That may be seen page 40. And I am behind the bar since last 265 days.
Yes, Sharma.
Last occasion, service of notice was asked to, I've been trying since the morning to contact the concerned office lordship regarding service of notice. It has not been received.
Taken, the other day also.
Lordship, the victim has already been examined, lordship.
Victim examined.
Victim examined turned hostile.
15 examined, turned hostile. Now,
The parents are lordship submitting the case, but
now, anything about your police officer notice and all?
lordship, I've been trying to contact since the morning, lordship.
You just try it. We are taking up in the second. Or tomorrow, either way.
Paid we at 2, my lord.
Huh?
2 p.m.
No, he's saying tomorrow. Let it be on tomorrow.
Tomorrow.
Okay. Mr. The scan copies call for has already been received. Mr. Sharma, B. Sharma, Learned Counsel submits that matter may be listed tomorrow. In the meantime, he shall obtain the instruction from the concerned police officer as regard service of notice upon respondent number 2. There is allowed list this matter tomorrow.
All right.
Please, your lordship.
Yes.
In this case, it's 439. Well, the CD and postmortem report along with the forensic laboratory was called for. He is already behind the bar for 73 days.
Where is the FIR?
20.
Where is the FIR?
My lord, page 9, my lord. There's a 2 FIR, my lord, page 9. No, this is the first FIR.
I'm sorry, my lord, here. No. Wrong CD has been given. 28, I think, is not. Surfarazation, no, another Islam.
Where is the girl now?
She is dead, my lord. She has committed suicide, my lord.
Allegation is that she was missing. You have abducted.
Maybe
There's an allegation that.
Then,
my lord, your second FIR was lost. That her body was found after 4 days, my lord. That was purely suspected. That is why, my lord, CD was called for along with the postmortem report, whether it is suicide or forensic report.
Where is the case diary?
I have to verify, my lord, wrong CD has been given. In
Okay, when?
Today itself, my lord, after some
Okay.
time. Or after some time.
After some time.
The CD has come that
35 minutes.
minute.
29.
May I please?
Just a minute. Yes.
May I please, your lordship?
Sorry, my lord, this scan copy I have not yet seen, my lord.
You want to go through it?
I have to go through, my lord.
The scan copy is called for by this court under its order dated 23/4/2024 has been received.
Pocso, no? Regarding service also, my lord, we have to see, my lord, because Pocso matter, my lord.
Service is AD card not yet received. Office note dated 17/5/2024 reflects that service in respect of respondent number 2 is not complete. Registry shall update the status of service by putting a note. Parasar, learned additional public prosecutors may be granted some time to go through the scan copies received from the trial court. There is allowed list this matter on next week. Monday.
Deeply obliged.
Yes, what is this?
Happy before lordship.
Yes.
I am arrested on 24th.
What is the FIR?
FIR well page 13, my lord.
1-3.
Yes, my lord.
Now,
My lord. As per the FIR, my
no
lord.
charge sheet file.
No, Lord.
No, my lord.
As per the FIR,
Appears that, my lord, those, my lord, ammunition was seized from the one person, accused number 1, my lord. My lord, page 14, my lord.
who are this person here? Let us see.
There
Who are
are
the petitioners?
there are 5 person, my lord.
All named in the FIR are
Yes.
before.
Yes, my lord. Now I was arrested because on the basis of statement of the accused, my lord, main accused, my lord, from whom the position was recovered, my lord. Initially, 2
Just
persons
tell us
were
the
arrested, my lord.
tell us the names. Who is petitioner here?
Petitioner here is, my lord, page 14,
Thomas.
Thomas Langthasa, my lord.
Now let us see the FIR. What is the allegation against Thomas?
As per the FIR, my lord, 1 barrel gun has been received from these 2 persons, my lord, who were subsequently arrested.
Just a minute. You are Thomas, is not it?
Yes.
You are not named in the FIR.
I'm in the FIR, my lord.
Where is that? Where
Second
is your
page, my
role,
lord.
huh?
Page 14.
Page
La-
14,
Last
yes.
paragraph, my lord.
Yes, the last paragraph.
Yes. And last, my lord, based on their statement, my lord, last 5 lines, my lord. Another 2 persons, namely so and so, were arrested.
Thomas, I am not getting Thomas now.
Thomas is there, Lordship.
Bonus
Bonus. His
Bonus
name is also
Langthasa, my lord.
alias Bonus.
See, one also based on their statement, another person Kumut Farlong, Rothai,
Yes. And
Delong Fangluan, Bonus Langthas.
yes, he is Thomas, Lordship.
Then
Bonus,
you'll have to
alias.
say that Bonus, Thomas alias Bonus.
Yes, my lord. Yes, my lord. So that was and from his position, my lord, there are 2 persons, my lord, from whom position it is also not clear. But even assuming, my lord, that this has been recovered, my lord, only single barrel gun, my lord. That is, my lord, handmade, my lord. My lord, already, my lord, today I'm 86 days, my lord. Length of detention may be considered.
Hey, Lordship,
And my lord, my wife is, my lord, problem, my lord, is a patient of psychiatric, my lord.
You will
I
be.
have not enclosed, my lord.
Until and unless you become a good person, she will be.
No, my lord, my lord, it is, my lord,
See,
as per the instruction, my lord.
on the basis of information,
Yes.
somebody arrested. Then somebody led to recovery of AK-47, what not.
Yes.
Then on the basis of investigation, grenade, then rifle. So I think police should be given the time to further
main
investigate.
accused, Lordship, 2 persons were there. One is Manik Haflongbar and another is Mijesh.
Third,
My lord,
what is his role?
Yes, that is
Same in the
same,
FIR.
same. Lord.
Otherwise, my lord, that that ammunition has not been seized from us, my lord.
No,
Yes, that we know, that can be,
That
that can
may
be at a
considered, my lord.
later stage, not at this stage investigation.
My lord, already 86 days, my lord, 90 days is the judicial period, my lord. Kindly detention period may be considered. 86 days, that is enough sufficient. I have, my lord, I have already get, my lord. What more, my lord?
Hard. We are rejecting it.
My lord.
We are rejecting it.
My lord, on any condition, my lord. On any condition, my lord. 86 days, my lord. 90 days is the statutory period, my lord. On any condition, my lord. Strict condition may be imposed.
You will be out if they do not file charge sheet. I will not, this court will not be part of this.
My lord,
Or we are
only
fixed,
on the basis
we are asking to return back the case diary and fixing it after 10 days.
my lord, may kindly then next week may be posted, my lord.
You return back the case diary.
Up to that,
Then
my
have
lord,
the
status.
instruction.
Up to this status may be full, my lord. Let it be posted.
Why up
next
to date case diary? They may conclude the investigation in the meantime.
No, my lord, whether anything material seconds.
Now we are rejecting it. This is an application under section 439 of the Code of Criminal Procedure 1973. Praying for granting regular bail to the accused. How many petitioners? Only one, is not it?
Yes, my
accused
lord.
petitioner, namely Thomas Langthasa alias Bonus Langthasa, who has been arrested in connection with who was arrested on 24/2/2024 in connection with DFU PS case number 10/24 under sections likhi lo bagote kini page 2. An FIR was lodged by who lodged this FIR?
Was lost by my lord. The one SI, my lord.
Lodged by
Boom.
JS.
Lodged by one JS Khobung, KHOBUNG, Inspector of Police. Inspector of Police. The FIR alleges that on the basis of specific input regarding illegal arms dealing by a group of miscreants in Karbi Anglang district, accused persons, namely Malik Manik Haflongbar, NIJESH Langthasa, were picked up as suspect from the Diffu town area, and they disclosed that they are involved in the arms dealing, and another person, namely Raju Langthasa, from who is a resident of Dima Hasao district, is also a part of the aforesaid gang. Full stop. Accordingly, said Raju Langthasa was also picked up, and who led to recovery of one AK-47 series rifle, 3 numbers of .32 pistols with magazines, and 3 numbers of live hand grenade. These persons were arrested. In the meantime, on the basis of statement of the accused Raju Langthasa, on the basis of the aforesaid arrested accused, the present petitioner was also arrested to be a part of the aforesaid group. And what was recovered?
From another co-accused, both of them are arrested.
Okay, the petitioner and the co-accused, namely, that is Kumud Phonglo.
Elias Rothai.
Kumud Phonglo, Elias Rothai, were arrested and
one handmade single barrel gun.
one handmade single barrel gun was recovered from said Kumut Fanglo. Full stop. Full stop. The peruse the material available, peruse the case diary and the materials available on record. The learned counsel for the petitioner contends that nothing has been recovered from the present petitioner, inasmuch as he has been arrested on the basis of the statement of the co-accused. It is further contention of the petitioner that already 86 days has been, it is further contended that the petitioner has been in custody for last 86 days, and therefore, considering the above, the petitioner shall be granted bail. Full stop. Peruse the case diary, also peruse the material available on record. The material reflects that full stop. The case diary reveals sufficient incriminating materials against the petitioner as well as other accused persons. Considering the nature of allegation and also in view of the submission of the petition, additional public prosecutor, that further in which further custody of the petitioner may be necessary, in as much as they are in search of some other accused persons who are also involved in this case. And therefore, at this stage, what about that Kumu who that fled away, escaped?
That person also arrested, my lord.
Arrested. Considering the above, the present application, this court is of the view that petitioner has not been able to make out a case for grant of bail. Accordingly, the present application stands dismissed.
Obliged, my lord.
Return the case there. It's up to you. If you don't file submit, they will get bail. That's all.
Please, your lordship.
Yes.
Lordship, application under 439. The petitioner behind bar for 46 days. Allegations under 120B, 420.
Where is the FIR?
FIR page 8.
Eight or 10?
10. Translated copy.
How many days?
46 days.
Statutory period is 60 days, lordship. Lordship, we will prove our innocence in the trial.
Prove your innocence in the trial with the hospitality of the state.
My lord, she in his statement said that one person Singh, he approves her, and that he has contact and men can be arranged. My lord. With the support of some other person, she arranged some men and subsequently taken 50,000 from each. My lord, she said, but she said that I have not taken this, I have taken and given to that person.
Who is that person?
One Nangal Singh. Singh.
What about Mongol Singh? Mongol is arrested?
Not yet, my lord.
What is the name of the other accused? Mongol Singh.
NANGL, Nangal Singh.
Hard. You are rejecting it.
Lordship, kindly, it is already 46 days, Lordship. 60 days is statutory period.
Get after,
Lordship,
if they fail to file charge sheet, get it after 60 days.
Lordship, investigation is already done completely.
There may be some other also.
That's why tell me the name.
NANGL, Nangal Singh.
And the present is an application under section 439 of the Code of Criminal Procedure 1973 seeking bail by the petitioner who was arrested on 2/4/2024 in connection with Tezpur PS case number 167/2024 registered under section 120B/420/506 IPC. The allegation made in the FIR is that the petitioner introduced herself to be a person who can provide job at Northeast Military Engineering Services on contractual basis, and he asked the informant to arrange for 30 boys for such job. Accordingly, the informant arranged 23 persons from Dibrugarh and 7 persons from Tezpur who were interested in doing such contractual job. Accordingly, altogether, how many appointment? 17 appointment letters were handed over to the informant, and it was informed that other appointment letters has not yet received from Northeast Military Engineering Services. Full stop. For such, in lieu of such appointment, the informant demanded 50,000 each, and altogether 1,50,000 through online payment mode were made in favor of the accused for issuance of such appointment. Subsequently, the informant came to learn that all these appointment letters were fake and fraudulent one. Full stop. Accordingly, FIR was lost, petitioner was arrested. The case diary called is produced. From the material available on record, it is this court is of the prima facie view that this is a group who is luring unemployed person and extracting money by issuing fraudulent appointment order. Full stop. Another person, namely, where is that? Nangal Singh, NANGAL, Nangal Singh is the main culprit, main kingpin in the entire racket, and he has not yet been arrested. Considering the matter in entirety and stage of the investigation, this court is of the view that further custodial interrogation of the petitioner, further custody of the petitioner may be necessary in this case. Accordingly, the bail application stands dismissed at this stage. Full stop. Case diary be returned back.
Yes. This is a second time bail application, Lordship. Today, Lordship, 66 days, Lordship. FIR, Lordship, will find on page 16, Lordship.
Page 16?
Yes, Lordship. My name is not there in the FIR, Lordship. And its specific, Lordship, it is recovered from one Abu Hanif.
What is the order of rejection?
Lordship will find on page 22, Lordship.
What is the period?
90 days.
90 days.
But recovery is not from this.
Recovery, matlab, he confessed in his statement, he doing this and.
Whatever comes so early.
Lordship, 1 month ago, Lordship, it was rejected, Lordship.
He is doing business in, selling this fake money in.
File a charge sheet.
Charge sheet, matlab, not yet.
What is the stage of investigation?
This case, we have received 18/5.
Last date?
Receive on 18/5, but last entry is up to 8/3.
Mr. Parasar Larnes, additional public prosecutor, submits that he may be allowed to update a case diary by next week. Diary is allowed. Please this matter on. Have
from Lakhimpur,
either have that when next date? Third.
Can it be on 4th, Lordship?
4th of June. On that day we'll consider.
Highly.
You fail in your duty, we cannot help it. Investigation is complete and you are sitting over, they will go. That's all.
May I please, your Lordship?
Yes.
Hello, Lordship will find FIR page 11, my lord.
Yes.
Recovered from the cow shed of the petitioner's premises.
Uh-huh.
Page 11 is the FIR, my lord.
Yes.
On 14 March, they came to the petitioner's house, my lord. While Mrs. 5 months pregnant, my lord, while no male members at home, my lord, this contrivance found in her house premises at cow shed, my lord. And accordingly, on same day, she was arrested, my lord.
Her series file or what?
Still under investigation. Lordship.
Who are you?
I'm my lord. I am Jomna Yasmin Borgnia, my lord.
Let us see the FIR.
Yes. Yes,
Read
11.
it.
I read, my lord?
Yes.
Yes, my lord. I have the honor to report that on 14 March 24, received an information from reliable source by me at 3:30 p.m. regarding a large quantity of NDPS particles had been kept concealed by one so-and-so in her house premises at Loknathpur under Dholai PS. The informer also informed that the Jomna Yasmin is involved in illicit trafficking of the narcotic drugs. Accordingly, informed the Honorable Officer who was present at the PS and so and made by the officer in charge of the PS case dated 14 March 24. Following the police team of the Dholai PS staff was constituted, conducted the operation, and the Honorable SP Sir, along with the OC Silchar PS, arrived at the Dholai PS, led to the search of operation as follows. The Dholai PS police is constituted on ISP Manoj Borua, I, along with the above PS police team under the leadership of SP Kasar, accompanied by OC Silchar PS, taken under the Dholai PS at 3:50 p.m. with the department MB bearing number Swencho and Sajad Hussain Laskar.
Okay, fine. Yes. Yes, what is your case?
My submission means, my lord, then my lord, and 5 months pregnant at the time of my lord, no male members found. Who kept this all this contrivance thing at the cow shed, my lord? I'm not aware of this fact, my lord. When they arrested, they've searched and found this goods in the premises, my lord. Since my husband worked in the Bangalore, my lord, the daily wage, and my brother-in-law also male members also available. But on that at the time of incident, no male member available at then. So being not found any male, I mean be arrested in this case, my lord. So my humble submission, my lord, since my lord, who has please kept this thing or this contrivance good? I am not aware, my lord.
Statement of these 3 persons. Who's those were seizure witness.
Sorry.
We are rejecting it. Hard.
One prior, my lord, since 5 month pregnancy, my lord, so that corrected those, give them medical based care. So that, my lord.
Hard. P.K. Deka, learned counsel for the petition, and Mr. B. Sharma, learned additional public prosecutor. Present application under section 439 CRPC referred by the accused, comma, namely Jamuna Yasmin Borbhuya, alias Jamuna Yasmin Borbhuya, comma, is seeking bail in connection with Dholai PS case number 49/2024, registered under section 21 within bracket C of the NDPS Act for grant of bail. The basic allegation in the FIR to the FIR in nutshell is that the petitioner, that the informant police officer on the basis of source information recovered how much? 20 recovered from the possession of the accused petitioner 20 numbers petitioner 1.085 kg of suspected brown sugar is kept in a concealed state in 20 numbers of plastic soap cases. Full stop. Accordingly, she was arrested. Full stop.
Item was recovered, Lordship.
Huh?
Another, Lordship,
And
11.316 kg of heroin.
okay, okay, and another 11 numbers of lead, and
11 kg, Lordship.
11 number letter break.
11.316 kgs of brown sugar also recovered.
Heroin, Lordship.
Heroin also recovered from 11 numbers kept in a concealed state from 11 numbers of leather bag. Peruse the material available on record. Also peruse the statement of the witnesses. So statement of the seizure witnesses. First, perusal of the material discloses that will not say anything. Then you will be in problem later on. This perusal of the case diary. In the case diary, there are sufficient incriminating material against the petitioner. And though investigation is progressing, however, it is at very initial stage. Considering the above, this court is of the view that this is not a fit case for grant of bail. Accordingly, present application stands dismissed. At this stage, it is submitted by Mr. Deka, learned counsel for the petitioner, that the petitioner is carrying 5 months pregnancy, and therefore a direction may be issued to the authorities, that is investigating officers, jail authorities, to take proper care of the considering the above. And at this stage, countering such, not countering, Mr. B. Sharma, learned additional public prosecutor, clearly submits that he will instruct the investigating officer so as to take necessary care of the medical care of the victim. First of all, be that as it may, it is provided that the authority under whose custody the petitioner is shall take due care of take due medical care due medical care as relating to her pregnancy.
Deep law classes.
Yes, that is returned back. Huh? No. You want to say?
This is the one of the person, the property lordship owner.
Where is the FIR?
FIR lordship on page 12 lordship.
FIR is lost by Rumi Jalan.
Rumi Jalan. She is the owner of a property lordship. And there she says lordship, some authority was given to his wife lordship, and in taking the advantage of that lordship, he obtained a loan lordship.
Yes.
Very fast, lordship, in the paragraph of the FIR itself says, which I have employed Srimati Nirmala Devi Casual to develop. Particularly, she is my wife lordship. And it is a case of 2016 lordship. Fact is that, my lord, yes. The petitioner.
The landowner said you develop this property that has been mortgaged in some other cases and loan not paid.
A loan around 3 crore and signature, close. Fraudulently taken the signature, cross signature of Rumi Jalan. Now, FSL also stated that as per the FSL report is not the signature of Rumi Jalan. FSL. And
who is the beneficiary of the loan? This person.
Yes, his company is the director. And loan is around 3 crore. And when bank notice came to the person, informant, then only they came to know that there is a loan, a huge loan, 3 crore. And signature force, that FSL report is available. Rumijala's signature is not there. Other bank, branch manager of the bank, statement of the, as per the branch manager, is it seems the director, Suresh Kejriwal, has committed the fraud. So, maybe some bank official also they are not yet come on, without they may not be properly verified. That is also one of the aspects. But yes, taken the take signature fraudulently taken the loan.
How this paper came to the hand? Though these persons were made guarantor. Informants were made guarantor. Because they own some property. So the notices come to them as guarantor. And that notice, it is from the forensic report that guarantees those signatures were fraudulent.
2016 case already cooperating with the investigation. And moreover, lordship, I have heard that some of the amount has already been paid, lordship. And the second aspect is that the property which was kept as mortgage, lordship, is still here, lordship. It is not sold out. When IDBF bank filed the case before DRT, then DRT notice came. Then only everything come on. Now, regarding the payment, lordship, some amount was supposed to pay around 30 lakhs, lordship. 30 lakhs has been paid, lordship, as per our information, lordship, to the bank.
Payment of bank is a different issue. Payment of bank is between you and the bank.
Mainly, basically, that is the case, lordship.
That is the case. You and the bank. In earlier cases, bank loses FIR. Bank says that you have done this, that. Then bail was granted on the ground that mistakes are committed. Bank officials are not accused. Isn't it? Bank officials are not accused.
As per the last note of the IO, is 18.5. 18.5, especially all this institution, but Suresh Kumar Kejriwaলৰ বিৰুদ্ধে সুপৰিচিত হৈছে মোকদমা প্ৰায় শেষ হৈছে অকল অভিযোগনামা দাখিল কৰিব বাকি আছে. That is the FSL all this received. That is the last note.
Let us do one thing. Let us return back the case there. And we'll fix it next week. It's now ball is in your court. Then we'll protect since already here investigation in then.
Cooperating,
investigation is because see at this stage their interrogation may not be necessary because vital issue was whether that signature belongs to
FSL.
that person and who is the beneficiary of that fraudulent document. That's all. The two things are required here. If that is collected, or we make it absolute.
I have
Okay,
also.
list is Parasar Learned Counsel for the additional public prosecutor. Order time to return back the case diary and get the updated case diary is allowed. List this matter when?
Court.
All this for
Well,
is a difficult day. 30. Order, password is second.
30.
Much obliged, Your Lordship.
In this case, Lordship, earlier we could not. In additional affidavit, Lordship, is number 23.
What is the case? Tell us first. We'll come to the additional 438. Where is the FIR?
Page 23, Lordship.
Where is the FIR?
Yes. Page 23, Lordship.
Page 23.
Radio says paper.
Earlier FIR was not there.
My lord, the only
Third up, yes,
the
Lordship.
cause list shown deputy SGI because of the cause list shown deputy SGI because of that file also not given to us. PP also there. So why central government made a party? We don't know. My lord.
Third up, yes, Lordship. West Bengal.
Oh, West
Third up,
Bengal.
yes, Lordship. West
Bengal.
West
Then how
Bengal,
can
Lordship.
we go? Yes, jurisdiction.
Allegation.
CD. West Bengal, my lord, how can we?
How can we take this?
First, 15 days time. Involved in the Lordship, in my petition, Lordship,
Hard.
23.
At counsel for the petitioner. The present application is filed on bail, even in interim. If it have been arrested, that is a different case. Transit bail.
Page 20, page 12, Lordship. I have annexed page 12, Lordship. I have
Case
annexed
12.
judgment, Lordship. Jurisdiction, Lordship.
Till his appearance, my lord, can I bring the CD also?
What is the ratio in the judgment?
Lordship,
Tell us the ratio. That we understand that what is the ratio laid down the judgments that you are relying on? Or you want us to read the whole judgment? Then your presence is not required. No lawyer's presence is required. We'll read petitions and pass orders. What is the necessity of a lawyer? Your case is that FIR is lost this West Bengal. You are apprehending arrest. You have filed an application here. Admittedly, we don't have a jurisdiction. Now you say that there are some judgment. What are the ratios of this judgment? Huh? No, that is your prayer. That is not ratio. Your prayer is that till my appearance 438, that this court can grant interim anticipatory transit anticipatory bail. What's that? What is the intent of 438? What is transit bail? Tell us. Yes.
residence of
These are facts. You are permanent resident of this. This page 11. A notice issued to appear. 41A notice. Plus. Yes, tell us what is the ratio in this regard?
order, Lordship, page number
Where is the judgment? We will not go by that interpretation. We want the judgment. What is the? You are taking responsibility of a citizen's right under Article 20. Vacate the interim order. Connect counsel for the petitioner. Is that she may be granted time prepare and argue this case. That is allowed. Please this matter. Interim order pass earliest. Address us on that. Huh? No interim order. Okay.
Please, your lordship. Yes. 438 application and FIR is at Annexure 1, page 12. This is regarding money laundering.
Is
Page 12 is the FIR.
interim order earlier?
No, lordship. Lordship, in this case, petitioner hearing. An used car dealer.
Huh?
He was doing with second-hand car business. Have a next.
What are the offenses?
Lordship, a list the offenses under 424.
What is the punishment under 7C and 7C1 and 7C2?
First offense.
Bailable. First offense, these are bailable. Lordship, it is no person shall carry on the business of money laundering unless he holds a valid license and certificate in his behalf. Whoever contravene the provisions of the section shall be punished with the first offense for a simple imprisonment which may extend to 3 months, or with fine which may extend to 500 rupees, or with both.
Third. Counsel for the petition. Hard. Present application is filed 438 CRPC. Paying for pre-arrest bail. Who is apprehending arrest connection with Demo PS case number 04/20. The basic allegation leveled in the FIR that the petitioner one petitioner, na?
Yes, Lord.
Yes. Petitioner is involved in illegal money lending business. So, peruse the case diary produced. But there are allegation of extortion. What
That
will
is not
happen?
correct, Lordship. I have annexed 2 affidavits by 2 of the customers. They stated that they sold their car. There's no extortion, Lordship, and nobody has complained. Only this FIR is lost by the informant, that is a police officer. Not
No, that we understand. People may, out of fear, may not lodge FIR.
Lordship.
Is there any bar?
No,
police
no,
lodging?
no, Lordship.
Then don't argue that.
Lordship, no. Nobody has alleged that I have extorted. And I have the trade license also of the use card. Lordship, I have annexed. It is at annexer to page 17. Lordship, that allegation is not correct.
There was the material. Nobody has said that. Have you seen this? There is the material available on record, including statement of the witness. The perusal of the material available on record. Seen that a case under section 7 within bracket 1 or and under section 7 within bracket 2 has prima facie been made up. However, such offences available on the first instance, the present case regarding any earlier relating to the other allegations. No sufficient materials are available for allowing custodial integration of the pit. In as much as the persons who had taken loans from who has allegedly taken loan from the informant has not alleged any had not made any statement involving any cheating or the above, the present application stands here before the IO. Yes, there is returned.
That's all.
Lordship, case diary not received.
When?
5th of June, Lordship.
5th of June, interim to continue.
Lordship.
438 bail application, Lordship.
41 is my lord.
For 38 bail application, Lordship. FIR, Lordship, page 7, Lordship.
Same money lending, my lord.
Co-accused has already been granted bail, Lordship. This order, Lordship.
Yeah,
Any
in this
interim?
case, this case, my lord, in this case, no interim asan nine. No interim is not there, my lord. In this case, my lord, there are some statement of the witnesses, my lord, that by providing loan, my lord, thereafter, my lord, the accused person.
Who is this accused? Mokbul Hussain Pradhani. He is also accused here.
Yad Ali, my lord.
Huh? This Mokbul Hussain is part of allegation in this FIR. Why have you given this?
Lordship, similar case, Lordship.
Similar means?
Lordship, co-accused has already been co-accused, Lordship.
In this case, co-accused. Mr. Public. What is the judgment, Supreme Court judgment?
For judgment, my lord, I will provide, my lord, right now.
That same bench should be legal. It's submitted by the learned additional public prosecutor that co-accused has been granted anticipatory bail arising out by a coordinate bench in AB 1061/2024. First up in registry to list this matter also before the appropriate bench in terms of the rendered by the Honorable Apex Court in Swenso versus Swenso. Which is the case?
AV number 10.
Interim or no interim? Terms of notification. Yes, next case.
42.
Section 2022.
In terms of decision rendered by the Honorable Apex Court in
2022, volume 10 SCC
819. Party's name?
Name is Lordship Abhayananda Sharma. State of Bihar in another.
It clears. Item 42, I think CD is not available.
It is not available.
42, my lord, case diary not received, man.
I'm on an interim.
When?
42 case diary not received.
When?
My lord, on 5th of June.
5th of June, interim to continue. Yes, Mr. Kolita.
The petitioners are on interim, my lord. Lordship will find the FIR at page 13, my lord.
Theft of bicycle, my lord.
My lord, five accused persons were named, my lord. Here, accused number 4 and 5 is before your lordship, my lord. May I read, my lord? বিন নিবেদন এই যে যোৱা ইংৰাজী 8/4/2024 ইংৰাজী তাৰিখে ৰাতিপুৱা 8 বজাত মই ডলেৰ পথাৰ হাফিজিয়া মাদ্ৰাছাৰ ভিতৰত বেৰৰ কাষত মোৰ চাইকেলখন থৈ কামৰ বাবে বাহিৰলৈ ওলাই যাওঁ। আবেলি মই 4টামান বজাত ঘূৰি আহি দেখা পাওঁ যে মোৰ চাইকেলখন কোনো অজ্ঞাত চোৰে চুৰ কৰি লৈ যায়। পিছত ঘটনা সংক্ৰান্তে পুলিচক খবৰ দিয়াত পুলিচে ৰাতি 9:30মান বজাত উপস্থিত হৈ স্থানীয় লোকৰ সহযোগত ডলেৰ পথাৰ
What is his role? Are 3 accused and Imdadul.
CCTV, my lord,
That
identified.
CCTV says, and they leading to discovery of some, not only the cycle, some machines and all.
Yes, some
What is his
water
role?
pumps also recovered.
What is his role?
No, because all are, my lord, are associated with each other, my
So
lord.
anything, any material against him?
Yes, my lord, other accused stated that, my lord, he is also, my lord, along with them.
Did you record your statement?
Yes.
Statement recorded. Yes.
Here is the material available on record. Considering the nature of allegation and the material so far collected, Mr. Swenso. Is there a produce? Same is perused. This court, under its order dated 30/4/2024, granted interim pre-arrest bail to the petitioner, and case diary reveals that after such protection, the petitioner had appeared before the IO and got his statement recorded. In the meantime, the stolen property has also been recovered from the possession of the other co-accused. The basic material against the petitioner is that he of the other arrested accused. Considering the nature of allegations and materials collected, and also considering the fact that the petitioner has cooperated with the investigation, material on record suggests that petitioner tried to influence tried to influence any witnesses. This court is of the view that no custodial interrogation of the petitioner shall be required accordingly. the interim order repetuation. Obliged. Yes.
Before my lord, case diary not received, petitioner is in interim.
When?
On my lord, 11th of June.
11th interim to continue.
Obliged.
45 case diary received.
What is the FIR?
12.
Who are you?
He is the dealing assistant of the office.
John
Of the,
Deca.
yes, ma'am. There are materials in this case, ma'am.
You are a dealing assistant. Your job is to some office note, not the job to post the signature of the officer and issue birth certificate. Huh?
I'm not the authority to sign.
You are not the authority. That is the problem. You are not the authority, but you have issued certificate putting not your signature. Signature of the officer who is competent to issue certificate.
I'm not putting the signature.
Huh?
I'm not putting the signature.
My lord, police has also, my lord, seized other, my lord, total 11 numbers of birth, death and birth certificate, my lord. Yeah.
Heard.
Birth certificate is not identified the IO.
Two witnesses, one is, my lord, one Asa Karmi and my lord, one is, my lord.
Present application is filed under section 438 of Code of Criminal Procedure for granting pre-arrest bail to the in connection with upper PS case number 41/2024 registered under section 468/470. Full stop. The allegation clause in the FIR, inter alia is that lost by the medical FIR was lost by the FIR was lost by medical and health officer -1 Salkosa SHC, 2B, inter alia alleging that the informant could detect that birth certificate was issued by forging the signature of the informant, and on inquiry on information received from the parents of the child in whose name certificate was issued, that the accused, who is a dealing assistant of birth and death registration of Salkosa SHC, has issued the said signature. The material, the case there is perused. The material reflects that not only in the case of produces perused, it is seen from the case diary that the petitioner had purportedly issued more than 11 birth certificate forging the signature of the medical and health officer #1 Salkosa SHC Dhubri. Full stop. The stage of investigation is also at early stage. Full stop. In the backdrop of nature of allegation and materials available, this court is of the view that custodial interrogation of the petitioner may be necessary in this regard. Accordingly, the present application stands dismissed. Case diary be returned back.
May please, your lordship.
Yes.
The 430 bail application. In this case, lordship, the FIRs of two, case diary of two FIRs were called for, lordship. One in which we are seeking previous bail and the other lodged by us, lordship.
Okay.
Here, on the case diary of the present case is available. Maybe.
Okay, Mr. This court under is order dated 10/5, is that it?
Lordship.
10/5/2024.
Sorry, PS case is received.
Direct, call for the case diary of Nalbari PS case number 286/2023.
PS case 286 received, my lord.
And
the present case.
where is the other?
Paneri.
That was not called.
It is mentioned, lordship.
And Paneri PS case number 68 of 2023. Full stop. Learned additional public prosecutor submits that to Nalbari case diary of Nalbari PS case number 286/2023 is received. However, case diary of Paneri PS case number 68/2023 is not received. Accordingly, he pressed for an adjournment. Care is allowed. List this matter.
19/6. 19/6.
19/6/2020.
I'm not an interim, lordship. Short date may be given, lordship. No interim is there.
List this matter.
On 19/6.
19/6.
No interim is there, lord.
No interim.
One
He
month.
says
Then, my lord, on to 28/5, 28/5.
28, lordship, 29. 28.
No, 35 minutes.
35.
Obliged.
May I please, your lordship?
Yes.
438 anticipatory bill application. The last location case diary was called for, your lordship.
Where is the FIR?
FI page number 14, your lordship.
Yes.
14, 1/4. Ready, your lordship.
Notice. Postpo case, my lord, notice.
Through additional PP. Through additional PP.
What is the statement of the victim? Tell us.
Victim,
If this is not a case for pre-arrest, we will not issue notice, we will dismiss it.
Yes.
And if it is a case for grant, then we will call for the it's 13 years.
The case is under kidnapping. The FIR has been wrongly attributed, your lordship. It ought to have been 366A.
Heard. You are rejecting it.
One reasonable ground, your lordship, that the accused person is the driver and there is a dispute regarding parking. And come to the same village.
13 years. Does Ditto explain how?
They were just speaking, your lordship, as per the FIR, and it was an
Heard.
A and Iqbal.
The
A and Iqbal.
A and Iqbal learned counsel for the applicant. And Mr. Bothakur learned additional public. The present FIR on the basis of which the information on the basis of which the connected case was registered inter alia reveals the allegation that on 29/4/2024 at around 4 p.m. in the evening, when the daughter of the informant, aged about 13 years, went for her home to the market for purchasing books, the accused petitioner, with the help of another accused, drag her into their Maruti car and tried to raise her modesty. When tries to
On 29/4/24.
outraise her modesty, yeah? Try to outraise her modesty. When the girl raised hue and cry, the local people gathered there and the accused person fled away. Full stop. During the course of the investigation, the statement of the victim girl was registered under Section 164 CRPC. Full stop. The victim is aged about 13 years, and she had specifically implicated the present petitioner as well as the other accused named in the affair. Accordingly, considering the aforesaid material, this court is of the view that the petitioner is not entitled for privilege of pre-arrest bail. Accordingly, the present application stands.
Yes.
The case diary be returned.
Please, Your Lordship. FIR case, this kindly put the time being.
Any interim?
I am not in interim, Lordship.
Huh?
I am not in interim, Lordship. What happened in this case, Lordship? I am the driver, Lordship. Petitioner who is the driver of the main case, Lordship, Abdullah, Lordship. For that, Lordship, we are apprehended, Lordship.
Where is the FIR?
FIR page 9, Lordship. I read the vernacular, Lordship. It will be because translation is not.
Okay, when can this is Guwahati only?
One thing, may I tell Lordship? Lordship, maybe protect us. We will record our statement.
Wait till Monday. Wait.
Monday, 27.
Till Monday, wait. Okay. Or maybe Friday, if he can say Guwahati.
27 Monday.
Huh? Monday or Friday?
Okay, 24. Huh? Monday, 27 Monday.
Yes, there is 27.
20. No, 28 tomorrow, no, 34 to Sunday. And 28.
Okay, let us do one thing. Let us take this method at 2 or what? Okay, this is almost 1 only. Yes, repeat. Okay. Call for the leftover methods and those methods where none appears and all. Huh? Okay, leftover. Ready? Or at 2?
No,
Ready.
this I have done only.
Where is the FIR?
FIR page, my lord. 9, my lord. Annexure 1. This is the first FIR, my lord.
Annexure
1, my lord.
9.
Is suspected, my lord.
Okay. Went missing on?
Missing on, my lord, 15th, my lord.
On 15/8. 15/8. Then,
my lord, after the discovery of the, my lord, recovery of the dead body, they lost second FIR, that is annexure 2. All sorts of allegation was given that.
Where is the FIR 2?
To page 12, my lord. And he is already behind the bar for 73 days, my lord. 17 days left. I'll not prefer.
That
any-
only makes a huge difference.
Yes, my lord, that's there.
That's 17 days.
Yes, my lord, if the
Your
investigation.
right changes.
Yes, my lord, if the
If
investigation is.
till next 70 days they are silent, even if we reject today, you have a right.
Right.
But if tomorrow they file the search sheet, that right is
But
gone.
that's okay, my lord. I agree with that, my.
Okay, now where is the page 12?
12 is the annexure 2, my lord.
What is the age of the girl?
Is 16 years and the boy is 18 years.
Okay,
Have you seen?
now we understand what is the case. Let us see the case there.
Dead body was found on 8th.
Okay, just let us understand. First FIR was lost on
5th.
5th.
She
5th
was
missing.
She was missing since evening, matlab 6:30 about, matlab.
6:30. Then body was recovered on
Body was recovered on 8th.
8th.
8th evening, near matlab, railway colony, near an water tank. In the jungle, matlab.
Okay.
And
What is the postmortem report?
matlab decomposed stage, matlab
Decompose.
but postmortem report, matlab.
Okay, decompose.
Postmortem report also, matlab, that matlab, actual cause of death is not given, matlab, it is sent from Viscera. That report of FSL report is not
Okay.
available.
Okay. Now,
Otherwise, matlab,
what
there
is
is
the
no
material
rejection for-
against this
matlab,
person?
matlab, he is the lover.
Okay.
That is one of the aspects, matlab, and thing is that, matlab, police interrogated him in this meantime, around 7 to 8 times, statement. He is covering all the statement. He has revelation,
But
and
what is his explanation regarding her death?
regarding out it, when she was missing, and the father of the girl went to his home also, that, and at that time he was not there. His mother called him over telephone that he is in masjid, Then he came along with 3 boys. His friend's statement also available.
What they say?
They said that we all went to masjid and went to market, then came back. And
Three
all
of
this.
living.
3 boys. But he, in all the statement, he says that I have love relation, I have no, I cannot kill her. And decided about actual who is the man culprit. This is not yet
Heard. Mr. K. Bhattacharya, learned counsel for the accused. P. Sharma, accused, and Mr. Parasar, learned additional public prosecutor for the state respondent. The petitioner is seeking bail in connection with
Yes, case 2.
in connection with Bongaigaon PS case number 88/2024, registered under section 120B/302 IPC, read with section 6 of the Pocso Act. It is alleged in the affair that the minor daughter of the informant went missing from 6:30 p.m. on 5th of
5th of March, my lord.
5th of March 2024. And accordingly, an FIR was lodged. In the aforesaid FIR, in the affair, the petitioner was named as accused. Accordingly, Bongaigaon PS case number 85/2024 under section 366 IPC was registered. Subsequently, on 8th of March 2024, the dead body of the victim was recovered in a decomposed state from
Near
near railway colony, Bongaigaon.
railway colony, near a water tank.
Bongaigaon, near a near a water tank
Water tank.
at Bongaigaon,
Dangtol railway.
Dangtol railway colony.
Railway market.
Railway. Full stop. Petitioner was arrested on
My lord, 5-3, my lord.
5/3/2024. Full stop. The case diary produced reveals that the petitioner has been interrogated by the investigating officer for as many as 7 times. Full stop. The investigating officer also collected the postmortem report, and it reveals that body was in a decomposed state and the reason could not be ascertained. However, the part of the body has been sent for forensic examination, report of which is now awaited. Full stop. The IO has also recorded statement of the independent witnesses. Full stop. Considering the material so far collected, this court is of the view that no further custodial interrogation shall be necessary. Yes. The interrogation of the petitioner further reveals that he has duly cooperated with the investigating officer and he has thoroughly been interrogated by the investigating officer. Considering the stage of investigation, the period of detention of the accused petitioner and the materials so far collected by the IO, this court is of the view that further custodial interrogation of the petitioner may not be necessary in this case. Accordingly, it stands allowed to the satisfaction of Special Judge Pocso, Bongaigaon, 20,000. Call. You cannot, when you are not here, you are not here. You cannot come and jump inside. You will have to wait. Yes, what is your case?
I beg your apology, Lordship.
Yes, which is the item number?
11, Lordship.
What we have dictated, none appears. And when fixed, we have fixed 1 week, okay. On the prayer of the learned counsel for the petitioner, then I cover. Yes, and next, anything?
Date may be fixed,
Give a
Lordship.
date.
In this week.
No, not 28. Yes, same here. 28. And appears after at 2. Others at 2. How many meters are left?
Okay, there is a dear my lord.
1660,
my lord. And pursuant to this, the police has filed the FIR, taking it as a complaint.
What day?
No disclosure of the informant, my lord. No identity.
Heard.
That's, just I have to place on.
See,
No, no,
just
Malad,
let us
no,
assume.
to clarify, Malad, only to clarify. Malad, gist of the case is that, Malad, he has, Malad, he is being a power of attorney order, sold in the name of Nitu Das, and that land mortgage to
National Highway acquired.
acquired. Now they sought for, police authority sought for a report from the circle officer. Circle officer gave the report, just to place before the court. Circle officer gave the report that
Marketed.
already demarcated and 693 dead dark, original dead dark, that is Malad, around 9.70 R total land. Out of that 9.70 R, 2.94 R was regarding national highway. Remaining 6.76 are mutated in other person. And 6.76 is much more than 2 kotha 10 lasa. 1 kotha is 1.26 R. So 2 kotha 10 lasa is around 3.15 R. So as per the Latmandal's report, circle officer's report, 6.76 R land is mutated in other person. He being a power of attorney, photocopy of the power of attorney is also available, Malad. Only one other regarding that, one bail objection by the IO only. Stating that the accused person has not cooperated with the investigation agency, rather he has challenged the investigation. He has not appeared. Now he has filed an additional affidavit stating that I went several times, giving photograph also several times, but appearance is not recorded on. That is the Malad.
The irony is that, Milord, on 4-5 dates, I have
to place the matter.
Heard Mr. H.K. Das, learned counsel for the petitioner. Also heard Mr. Parasar, learned additional public prosecutor. Full stop. Decision application under section 438 CRPC for granting the privilege of privilege bail to the petitioners, namely Swenso, in connection with who is apprehending arrest in connection with Swenso. This court under its order dated 4/1/2024, while calling for the case diary, passed an interim order protecting the petitioners from arrest. The case diary is produced today by Mr. Paras. The basic allegation leveled in the FIR is that a plot of land which has already been acquired by the National Highway authorities has been sold by the accused. She is also accused. By the wife of?
Wife of the accused number 1. Husband will defraud the wife.
Okay, sold the land. Full stop. It is not discernible from the FIR how the present informant are related to the said land, or how are they aggrieved, inasmuch as the purchaser of the land has not preferred any filed any criminal complaint. Full stop. The IO during the course of investigation has also called from the report from the circle officer. Stop. Also peruse the report of the circle officer, which discloses that the land under the DUG numbers and patta numbers alleged to have been sold are alleged to have been sold is having a large chunk of land. We'll not say all these DUG number, patta numbers, large chunk of land, and out of the said land, one portion has already been acquired for National Highway, and land are still remain to be sold. Full stop. He has, the IO also during investigation says the power of attorney on the basis of which the accused has sold the property. Full stop. From the material so far collected, From the material so far collected, this court has not found any incriminating material warranting custodial interrogation of the petitioner. Full stop. Accordingly, the interim order dated 4/1/2024 is made absolute. Case diary be returned back.
Much obliged.
My lord, in this case, my lord, case diary was called for. Here, my lord, the actual fact is that there's a matrimonial dispute, my lord, and the village meeting was held, my lord. But the respondent came to the meeting along with the police, my
Where is
lord.
the
and
FIR?
Page 10, my lord. And the situation worsened and took a different turn, my lord.
Mm-hmm.
My
Just
lord,
see the FIR first.
FIR at page 10, my lord.
What is page 8?
Translated copy.
Huh?
Translated copy of the
Translated.
FIR.
Where is the vernacular?
Vernacular.
It's 10.
That is also English.
Not translated, typed copy, my lord.
Yes.
A matrimonial dispute was there, my lord. Because of that, there was a village meeting, my lord. So in the meeting, my lord, the husband came there by taking police along with him. And then, my lord, the occurrence was worsened, and then, my lord, there was scuffling in the police and the.
Actually, Lordship, what has happened, the mother of the victim girl, she had lodged this FIR that her daughter is continuous.
What is the girl victim herself has said about him?
Yes, Lordship, all the accused person. Lordship.
All the accused person.
She was
How many petitioners are here?
Five.
Five petitioners.
The
Three
victim
are
girl.
ladies, my lord.
Huh?
3 of them are ladies, my lord.
Thing is, Lordship, the victim girl, she was being kept under lock and key in the house, and she was being assaulted by the husband and family members. Thereafter, Lordship, when the mother lodged this FIR, and when the police went there to rescue her, the villagers were summoned, Lordship, and they obstructed her being taken away. Lordship.
Police also they were obstructed.
Yeah, they were obstructed, and one lady police, Lordship, her uniform was torn. The police officer suffered injury as well, Lordship. And a recording is also there, Lordship, of the incident whereby these accused persons were identified by the local villagers, Lordship. Including the village headman's statement is also there, Lordship. Lordship, kindly peruses this statement.
Just give us.
Yes, Lordship.
An application under so-and-so.
Is the Lordship statement of the victim.
The informant is the mother of the victim. Is that it?
Yes, Lordship.
Mother of the victim.
Sangita Bode, Lordship.
No, the FIR is lost by one
Parvati Swaragi.
No.
Parvati.
Page 10.
Yes, Lordship. Oral information was given by the mother,
come
Lordship.
on.
Thereafter-
It was caused by ASI Robindra Talukdar. Full stop. The is alleged inter alia in the affair that the mother of the victim telephonically informed the police station, which Simla police station, that her daughter, namely her daughter, had been confined by her husband, within bracket petitioner number 1 in this case, petitioner number 1 with bracket close, and has confined has no actually that her daughter had been continuously been physically assaulted by her husband, within bracket the petitioner number 1, and out of fear she tried to flee away from the custody of her husband. First of on such affair being on such information, telephonic information being received, the police party proceeded to the village to recover the victim girl. However, the villagers, including the petitioners herein, obstructed the police in doing their duty and also physically assaulted some of them. First, a specific allegation has been made that the entire incident was videographed and the village headman and the victim has identified these present petitioners in the commission of the offense. Full stop. Peruse the case diary produced, including the statement of the victim girl, victim lady, and the statement of the Tampura and other statements. Full stop. From the statement, it is their statement corroborates the allegations made in the FIR as well as affirms the role of the petitioners in commission of the offense.
For the all medical certificate, Lordship, of the police people, Lordship, they have suffered injuries. Simple.
Okay.
Pink flag.
Okay. The
Lordship will find
the injury report of the 2 police personnel also suggests injury, though it is simple in nature. Considering the material, considering such discriminating material, this court is of the view that this is not a fit case for grant of pre-arrest bail. First of, accordingly, the present petition stands dismissed. Case diary be returned. Yes, next. Yes.
The IA for consideration of bail in criminal appeal matter. The appellant has been convicted under section 6 of
the
Pocso Act.
6 of the Pocso Act.
Was that matter whether the victim was minor or not? That was the issue. And last
the appellant has served notice upon respondent number 2 through the stick. Full stop. However, in terms of the judgment of this court in Nayak, Deepak Nayak versus State of Assam, the petitioner is permitted to take steps for issuance of notice upon the respondent number 2 in terms of the aforesaid judgment and the notification issued therein. Full stop. After taking such steps, you take a step, they will obtain a report. The Deepak Nayak's judgment is you will have to give it to the registry. Registry will give it to them, then they will give a report. That's all. Accordingly, list this matter on.
in 1 week we can take.
Thereafter,
Thereafter-
say 1 week, they will serve the copy.
That week it may be fixed, my lord.
After 3 weeks, they will fix a date. Give a date after 3. 13th of June. Is this matter on 13th of June?
The criminal petition paying for criminal petition lordship seeking for filing appeal challenging acquittal.
Application for leave acquittal. Okay, hard.
Hard.
Counsel for the petitioner. Decision application seeking leave under section 378 within bracket 3 and comma within bracket 4 of the Code of Criminal Procedure 1973 against the judgment and order of acquittal dated 4/3/2024 passed by the learned subdivisional judicial magistrate within bracket M Bilasipara, comma Dhubri in CR case number 620/2019. Full stop. 2019. Issue notice returnable on. Is a leave necessary in CR case 138? No
Leave is
leave.
not required to be.
Huh? I do not think their leave is required.
No, lordship, in NI cases it is required. But in other cases not required. In
NI required.
In NI
Okay.
cases it is required.
Okay. Notice returnable on 24th of June 2024. Steps within 5 days both ways.
My pleasure, lordship.
Yes.
Lordship, service may be awaited.
Notice to the respondent number
2, my lord.
2 was issued on 8/5/2024. First up, await service report and list after 4 weeks.
Much obliged. Lordship, this misapplication was filed for correction of the prayer portion of the criminal petition number 514/2024.
Where is the what kind of change you want?
Lordship, actually, I have filed this for quashing of the entire proceeding. Specifically, I have not stated there. I have stated that in the main petition, I have stated that the FIR and subsequent proceeding arising out of that. But now here I have specified the search sheet and others. Lordship, here I have some in the main petition, there are some inherent defect. So I may be allowed to withdraw the
Withdraw and file this
Yes,
fresh
Lordship.
petition. Full
Yes,
stop. Where is the main petition? Give the main petition.
petition notice was issued, but I will have to withdraw and then I will.
Okay, you file it. Okay, main case to likhibo. Mr. S.N. Tamili, learned counsel for the petitioner, submits that there are certain defects in the petition, as well as he would like to correct those defects in the petition, as well as he would like to redraft, as well as he would like to make some additional prayer in this criminal petition. Accordingly, he submits that he may be allowed to withdraw this present petition with a liberty to file a fresh petition. The Borthakur has not objected to such prayer. Accordingly, the present application stands dismissed on withdrawal with a liberty as prayed for. Ayat likhibo, in view of the order passed in criminal petition number so, no orders need to be passed. Accordingly, this IS stands closed. Yes,
Here
what is-
the petitioner was convicted for 1 year, lordship, and there's a delay, lordship, for 753 days, lordship. And
You're
he's behind the
convicted
bar for 1 year.
Now, what happened to the conviction?
Lordship, subsequently he was arrested. He is behind the bar last 4 months, lordship.
What was the allegation?
Lordship, he with a
scuffle with another, and the present respondent number 2, he interfered there. And
You are in custody now.
yes, sir.
In the meantime, 1 year will be over.
Yes, sir. That is why, sir.
We will have to, we have 763 days. We will have to issue notice, or is it not?
Normally, it is not. But
Offenses under
324, he was convicted only 324. Lordship, page 18, Lordship, is the in revision petition, Lordship, page 18, operative person, Lordship.
Yes, Bothakot to condone the delay. Heard Mr. L.R. Mojumdar. Huh? A.Z. Ahmed, learned counsel for the sorry, you are here. A learned counsel for the petition. Applicant, not petition, applicant. The present application is filed for condonation of delay of 753 days in preparing the connected criminal revision petition assailing the judgment and order dated 9/2/2022 passed by the, it is a reversal. What happened to the trial court?
Lordship,
It is the first, huh?
in the appeal, Lordship, it was upheld. The order of CGM, it was upheld by session judge, Lordship.
So you need to
revision.
assailing the judgment and order dated 9/2/2022 passed by the learned session judge in criminal appeal number 15 of 2019, whereby the judgment and order, judgment and conviction dated.
Yes, Lordship.
That is, you have not written.
No, 29/5/2019.
29/5/2019.
Passed in GR case number 4577/2014.
Passed in GR case number?
Yes, 4577/2014.
2014. Whereby the petitioner was convicted.
Yes, for rigorous imprisonment.
For rigorous imprisonment, convicted under section?
Simple imprisonment for 1 year.
Convicted under section?
320.
Huh?
324.
324. And was sentenced to undergo simple imprisonment for
1 year.
1 year. Full stop. Mr. Bothakot submits that he has no instruction to instruction to object the delay. Full stop. Peruse the explanation given in the petition as regards the cause of delay in approaching this court in preferring the connected revision petition. Peruse the same, and after perusal of the same, this court is of the view that petitioner has successfully explained and that the petitioner was prevented by sufficient cause in not preferring the petition within a period of limitation prescribed. Accordingly, the present application stands allowed by condoning the delay of 763 days. I stands dispose of registry to list the connected criminal revision petition in the next week, subject to the same being in order and without any defect. Yes. I stand to
54.
May this one
yes.
of CRPC, Your Lordship.
Yes.
The FIR is page number 8,
What typographical error?
420 and 406. 20 and 406.
Typographical error to plead.
Typical error is the title page. Here I have typing is mistake. Yes, here mentioned that stone arrested, but they are not a stone arrested. This is the first crime of them.
You file an application under 439. Is it not? Now, what is the mistake? I is for what?
Mistake is that, Lordship, on the title page, Your Lordship, on the main petition.
Wrongly written as stone arrested
Yes,
in place
Lordship.
of.
In the an application under section 439 of
Okay.
the.
The present application is filed for correction of typographical error in the cause title of the connected bail application, that is BA number 1385/2024. In the cause title of BA application number 1385, what is that shown arrest?
Page number 1, Lordship.
Okay, okay. A word shown, SHOW, has been cause title petition. It is wrongly typed as shown arrested on 03/05/2024, whereas the shown word has inadvertently been typed in the sentence. Full stop. Accordingly, it is prayed that the petitioner may be allowed to correct such typographical error. Prayer is allowed. Prayer is allowed. And the petitioner, prayer is allowed, and petitioner is allowed to correct, delete the word shown by hand in the connected application. By hand in the connected application. Okay.
Arrested date
Before
also, your
the competent officials of the registry.
arrested date also, Lordship, on the forwarding here mentioned 3/4/24. 3/4/24. Forwarding.
Phone arrested. No, okay. I stands disposal. Now, what about this bail?
Yes, Lordship.
Where is the FIR?
FIR is page 8.
Regarding the bail, my lord, case diary is not available with us. No?
No, not even CD is not called for.
Yes.
Okay, main reason, this is an application suspension. Call for the case diary on. Yes. We cannot give you grant you bail. List this matter after correction.
Yes.
In the motion column on Friday. Okay. Without correction, we cannot dispose of this matter. Friday.
And case diary you may be called.
Okay,
If
case
not
for
supposed
call.
today, Itanagar PS.
Call for the case diary, fixing it on.
Friday.
Apparently, okay, there are some elements, but how many days you are behind?
48 days.
48 days. Whatever.
Yes.
406 and 420 of IPC.
List-
Your Lordship, my name, our name is not mentioned in this FIR.
Itanagar PS, I will get the case diary.
on Friday. Call for the case diary, fixing it on Friday. Bring the case diary. Nothing
Yes,
is there.
yes,
This is
yes.
not a case to be kept. Otherwise, we would have granted him today because of defect. We cannot.
Yes.
Yes. And this correction you would have allowed without an application. Anyway, yes. What is this?
It is a lordship. For petition, my lord.
Hmm.
An act proceeding has been initiated by the respondent against the petitioner.
Transfer of
For petition, my lord. The criminal case, my lord.
criminal case, CR case or GR case?
CR case.
CR case from
From, my lord, Difu to Guwahati or any other.
why?
Case 22, my lord.
Case code case
22, my lord. 22.
who is for the other side?
Respondent number 1.
Lordship, we have filed a written objection. Also.
This is not a case of transfer.
That transaction मतलब took place in party.
Argue on that point. But what is the provision under negotiable instrument act? Where was the bank account of the that informant? Where it was deposited? That's all.
That was deposited in depot branch.
Depot branch.
Account is there. The
Account-
jurisdiction fall under that.
That transaction took place.
Maybe what is the provision in the negotiable instrument act? It specifically says Roy's bank account situated. That's
Cause
all.
of action have arise there.
Here मतलब I will not be able to.
This cannot be said to be a fear.
This my lord.
We cannot presume, make a comment against a place.
Many cases are going on in depot. Not only that, my lordship, this person has cheated many people.
That is not that cannot be a ground for not granting transfer. Will be confined to the power of transfer, not others. Merit will not say.
Number 58.7.
Will be determined by the reference to the place where the check is dishonored. Check is dishonored where? What do you mean by dishonored? Let us go to the forget about this judgment. Let us go to the negotiable instrument act. Read the provision of jurisdiction. They are specific.
Yes. What আছে? Section 142, subsection 2.
142.
The offense under section 138 shall be inquired into and tried only by a court within whose local jurisdiction.
Subsection
2. Subsection 2. Subsection 2A.
Okay, that is the given specific.
Yes.
If the check is delivered for collection through an account, the branch of the bank where the payee or holder in due course, as the case may, maintains the account is situated. Is situated in Karbi Anglo. He maintains the
He
account.
is afraid of going to default.
This is not. He has
If
cheated. That was
if my
many
friend
times he has
ensures
called.
my safety, my lord, then my
Many
lord, I
times he
have
have called him.
Hard.
Around 2 to 3
are
years.
not, my lord, denied by him.
Huh?
There's filed written objection that.
Yes, I have not denied it,
my lord.
but there is no life threatening there. Even they have not complained about that in the police administration also.
Hard, Mr. Hard, Mr. I.H. Saikia, learned counsel for the petitioner. Also heard Mr. Fukan.
Yes,
A. Fukan, learned counsel for the respondent. The present petition is filed by the petitioner present a petition is filed. Presently filed under section 407 of the Code of Criminal Procedure 1973, praying for transferring NI Act case number 04/2022 pending before the learned Chief Judicial Magistrate Dufu, Karbi Anglang, to any other courts in Assam. The basic ground for seeking such transfer is that the commercial transaction out of which the check was issued, it took place outside DFU, and therefore the DFU courts shall have no jurisdiction to entertain such application. The further ground is that the petitioner suffered, got infected from COVID-19 virus for a prolonged period and his lungs were damaged. Therefore, it may not be possible to travel to DFU to contest the case. Yet another ground
Page 4, my lord. Last 4 lines, my lord.
is
Page 4.
Yet another ground is that the dispute arises out of is a contractual liability, and therefore negotiable. Therefore, a criminal case is not maintainable. First page.
Page 4, my lord. Paragraph 5. Last 4 lines, my lord. That apart.
It is also contended that there is imminent threat to the life and property of the petitioner in Karbi Anglam. Stop. In support of such contention as regards life threat, the petitioner has referred to communication, WhatsApp communication between the petitioner and the informant, petitioner and the complainant, to suggest that the petitioner was threatened by the accused. Full stop. Per contra, Mr. Fukan, learned counsel, submits that in terms of subsection 2 of section 142 of the Negotiable Instrument Act, the Chief Judicial Magistrate DFU is having jurisdiction to entertain such petition in as much as the bank where the check was presented by the petition by the complainant respondent is situated at DFU. First of, he further contends that there is no threat to the petitioner and the complainant is a law-abiding citizen, and he will not threat the accused if he participates in the trial, in as much as the what's up referred by the learned counsel for the petitioner cannot be said to be a threat to the petitioner, and such message was forwarded out of frustration as the petitioner did not return back the money. Full stop. I have heard the learned counsel for the parties. Section 406 of the Code of Criminal Procedure 407 of the Code of Criminal Procedure empowers uh, 407 of the Code of Criminal Procedure empowers High Court to transfer cases and appeals when it appears to the High Court that a fair and impartial inquiry or trial cannot be held in any criminal court subordinate thereto, or that some question of law unusual and that some question of law of unusual difficulty is likely to arise, or that an order under this section is required will tend the general convenience of the parties or witnesses, or is expedient for ends of justice. Full stop. Section 142 of the Negotiable Instruments Act 1881 deals with cognizance of the offenses. Full stop. Subsection 2 of section 142 provides that offenses under section 132 is required, shall be inquired into and tried only by a court, comma, amongst other, within whose jurisdiction, amongst other, comma, in the event the check is delivered for collection through an account, the branch of the bank where the payee or the holder in due course, comma, as the case may be, maintains the account is situated. Admittedly, in the case in hand, the check issued in favor of the complainant was presented by the complainant in Diffu branch of
SBI,
State Bank of India, where the complainant maintains an account. Full stop. Therefore, the contention of Mr. Saikia that the Diffu court shall have no jurisdiction cannot be accepted in view of clear provision of in view of the aforesaid clear provision of law. Stop. Now coming to the life threat of the as alleged, comma, the material available on record do not disclose that there is such imminent threat which may lead to which may create a situation where fair and impartial trial cannot be held by the Diffu court. Full stop. Diffu court. Therefore, in the considered opinion of this court, the present is not a fit case to exercise this court's power under section 407 of CRPC. Accordingly, present petition stands dismissed. Interim order passed earlier stands vacated.
There is no
That to be
threat.
observed.
You can appear.
There is the, in the.
To file an FIR, then again come back to us. Let us have the investigation and case that of that.
1 year. He's waiting. Let him appear.
Yes.
Yes.
My lord.
Most of them.
They are not well, Lordship.
Okay. Learned counsel for the petitioner submits that he is not keeping well today. Accordingly, prays for an adjournment. Mr. Padgiri, learned counsel for the
Respondent number 2.
respondent number 2, and Mr. Borthakur, learned additional
one.
public prosecutor, has not objected to such prayer. Accordingly, matter stands adjourned and be listed after 2 weeks.
It may be fixed, my lord.
Give a date after 11th of June.
Oblige.
Yes, Mr. Sahala.
Under Domestic Violence Act. My lord, the petitioner is was a married person, my lord. He has a with his wife for filing a mutual divorce petition. Mutual divorce petition was filed. In the meantime, my lord, the respondent.
What is this IA?
IA, my lord, for vacating of the interim order. Last time we agreed that the entire matter can be had because same thing is to be. Now, there was exchange of messages. I have annexed, my lord.
Mr. Sahala, let us do it on 24th.
For 24th, my lord, I shall be out of station, my lord, in the first week of June then. Because
he is having urgency, we know that.
Lordship, fact is this, Lordship. The client of my learned friend, he had married earlier. This fact was not disclosed to the.
Anyway, we'll go not today. Let us do it on 24th. You are having a
my
problem.
lord, I shall be out of India, my lord, for 1 week. Some Rotary conference.
Okay, proceed then. Proceed.
So, in the first week, my lord.
What you say? First week?
First week or second week, whatever I can.
No, when you leave.
Huh?
When
24th, I shall go and 31st.
Okay.
23rd is a holiday.
Yes.
20. Today is Monday. It will take some time.
11th of June, my lord.
No, it will be too much.
Or 6th of June.
6th?
6th of June. 6th of June, my
Or
lord.
very urgent that we should hear this today.
Okay.
Huh?
6th of June.
6th of
22nd, we have some problem. Tomorrow is 21st. So then 23rd is a holiday. That's why I thought we'll finish it upon 24th. But he's having a problem.
My lord, I have no problem.
Or today.
I am ready for today.
How much time will you take?
Time taken, my lord.
Okay. We'll take. When are you coming back?
My lord, 31st, I shall be coming. So it may be on 6th, my lord. My lord,
First, give a date of first week.
6th
Yes.
is, my lord,
Now we'll on first week we'll go by Mr. Roy's then.
Yes. Anyway, my lord, I have nothing to say.
3rd of June.
3rd. Okay.
Okay.
3rd of June. Okay. As agreed to by the learned counsel for the parties, list this matter on 3rd of June.
May it please your lordship.
Yes.
Appeal against the judgment passed by learned session judge for Udalguri, convict appellant under section 305 IPC.
For period of
7 years imprisonment, my lord.
7 years.
Yes.
Okay. This is an appeal under section
304
under section 374 within bracket 2 of the Code of Criminal Procedure 1973, assailing judgment and order dated 19/4/2024 passed by the learned session judge Udalguri in session case number within bracket Roman 2 subset 15/2018, whereby the accused petitioner has been convicted under section 304 within bracket B of the Indian Penal Code 1860 and sentenced him to undergo RI for 7 years and to pay a fine of rupees 10,000 in default, pay 10,000 full stop. Peruse the judgment, admit, call for the record, issue call for the record. Is it necessary, not necessary to respondent number 2? The board Thakur accepts notice for the state of Assam. No formal notice need be issued. Full stop. No formal notice need be issued. As comma in what is the notification that it is not necessary? But the respondent number 2 is not a necessary party. Accordingly, name of respondent number 2 is deleted from the area of parties. However, it is made clear that the respondent number 2 shall have the right to participate in the proceeding if she so desires. Full stop. Kept within 5 extra copies. Okay.
Much obliged.
Go, Mr. You wrong P. Huh? Item. Yes, what is this?
May I please, Lordship, this is a appeal, my lord, against conviction, my lord. The appellant was convicted for 10 years under 389B IPC, my lord. 3 years for 420B.
489B.
489.
Working homo section Perus the to Takibo admit for records. Any private parties? No.
Yes, my lord. Respondent number 2 is there, my lord, as an informant.
Not necessary. I got to niche delete correspondent.
Obliged.
Passman.
This is the lordship.
Yes.
Lordship, here we are agreed by the rejection of a Jimma, my lord, as regards my cows, my lord. The trial court, my lord, on both the occasions held that records were placed before the court and the cows were not, my lord, required for the purpose of investigation. But as there are, my lord, bar in item in section number in
Is
section
this matter on Friday?
Friday. Yeah, I'm deeply.
On Friday next. Thakur, you are free now. You are being made free.